Good day and welcome once again, Employment Law Show. Thanks so much for tuning into the show. The next 30 minutes will guarantee to be very informative and entertaining, so try to stick around for the entire thing. You want to reach out on the other side, 1-855-821-5900, help@employmentlawyer.ca, and the website pocketemploymentlawyer.ca, which we will dive into much deeper during the show, is always there for you, absolutely free and anonymous, and there is a contact button at the top right if you care to do so afterwards. Anyway, Lior, we're going to get to this today, my friend. Good to see you again. That is severance pay when a business closes due to COVID-19. Talk about a timely topic. We will get to that in just a little bit, but we always start off with a situation you've been dealing with of late, the week that was. How are you?
Well, John, you promised at the top of the show that the show is going to be entertaining. Does that mean I have to do some sort of a juggling act? I don't know. It's a lot of pressure.
Whatever you got. Do it.
Singing, maybe. That won't be entertaining. That'll just be scary. But we are here to, if not entertain, certainly inform and educate at a minimum. And hopefully let you leave this show with something that you've learned about your rights, about your employment law entitlements, because those are so important. They're important always, forever, but they're certainly important right now when we're dealing with the pandemic, when so many job security have been impacted, layoffs, we have terminations, we have changes, pay reductions, bankruptcies. All those things have been impacted and have happened over the past year. So if you need to know, and who doesn't, about your workplace rights, your entitlements, this is the show, this is the time and place where we can do that, tell you what you need to know, answer questions, and hopefully have you understand better the extensive rights that you have. And believe me, they are quite extensive. I don't care where you are in Canada, they're extensive. And if we don't get to cover everything that we want to or that you want us to, because we only have 30 minutes here, not a problem. Call us off air, call me at the office, email me. We'll give you that personal information throughout the show so we can have that personal and private discussion. There is no such thing as a bad question when it comes to employment law. You have the right to know your rights. So please don't hesitate to pick up the phone or send an email to make sure you do just that. But to get us started here, let's talk about a case that came across my desk. So our regular viewers know that when it comes to severance, it has to include all components of your compensation: salary, bonus, benefits, car allowance, etc. Well, I spoke earlier this week with someone who was let go from his job, and he told me that all he really has is his salary and his benefits. There was no bonuses or car allowance or stock options. But then as I dug a bit more into this, I realized that, well, there's something else that he has, and that is regular overtime. In fact, this guy worked a ton of overtime. Over the last 3 years, he'd average anywhere from $20,000 to $25,000 a year just in overtime. So when the company let him go, they let him go because of COVID. He had been there for over 10 years. They said, we're going to give you 7 months pay, okay? But we're going to calculate that on your base salary only. Well, first of all, John, 7 months pay is not enough for him. He's an older gentleman. I assessed him as being owed right around 12 months pay. But they're not even paying him a proper 7 months because they're going to say, we're going to only calculate it based on your salary. Well, what about overtime? That's $25,000 a year. So I told him, you're owed 12 months pay, but it's 12 months of your salary and your average overtime. That's a huge difference over what they've offered him. So I'm going to help him get that. It's not going to be a complicated process. I expect within the next couple of weeks this is resolved and he gets what he's owed. But there's a very, very important reminder there for all our viewers. If you work overtime, if that's a regular component of your compensation, if it's something that you can count on, maybe it's a bit more sometimes, maybe sometimes it's a bit less, but it's a regular component of a compensation, that still has to be included in your severance. We would simply look at an average. What do you earn on average a year? That would include your salary, your overtime, your bonus. Once we know what that figure is, that is the figure we're going to use to calculate your severance. Your employer may try to get away with saying, oh, no, just salary. That's all we're including. Can't do that. That would be a wrongful dismissal. The law makes the decision that it has to include everything. If you don't get everything, you know what to do. You call me, let me deal with it, let me do what I do.
You know, Lior, on the topic of overtime, even outside of a scenario where you're being let go, if you've worked a ton of overtime, maybe not as much as this guy, but you've worked a ton and they haven't paid you for it, can you go after them for it? And how far can you go back in history to get that overtime that's owed to you?
Yeah, generally you can go back 2 years, and yes, you absolutely can go back to it. Now, depending on the province you're in, there's different rules and thresholds for overtime. Sometimes it's 40 hours a week, sometimes it's 44. But if you are owed overtime and you didn't get paid overtime, yes, you can absolutely pursue that and go back 2 years. Remember, even if you're on a salary, if you work overtime, it has to be paid. Even if the company didn't approve the overtime, but you had to work it to get the job done, it was legitimate, it was real, the company has to pay for it. If you don't believe you're getting paid, if you don't believe that the company is right to deny you overtime, by all means, reach out to me and let's discuss it.
I know we throw it up on the screen all the time, but just in case, 1-855-821-5900. The website as well, employmentlawyer.ca. Again, ton of information there. There's also links to our long-running radio show. We take some of the calls, the good ones. We cherry pick them from our radio shows across the country, and we play them back, and we talk about them right here, Lior. Our first phone call for this show from the radio show is coming up right now.
I had my injury at work, and I was on workers' compensation. I was notified that I could return to work, which I've been with for 20 years, with the modified duties and modified hours. When I returned back, I found out that I was reporting to a director from a different department. He was handling now the area that I was handling for over 20 years. Can they do this to me?
So the devil here is in the details, meaning we need to understand whether this change in reporting, whether that's ultimately a demotion. All right. It's possible that they've done some restructuring, but it's not really a demotion. It's not a lower level job. A company does not have the right to just demote someone. OK, if they do, that could be a constructive dismissal. It's the type of change that an employee does not have to accept. Now, what's considered a demotion? Really, anything that's a position that's less senior, less prestigious, even if the pay is the same, but if the position is less desirable or prestigious, it could be considered a demotion. If you were a manager, now you're not a manager anymore. If you've gone down certain levels within the company's hierarchy, that would be a demotion. Definitely if it's a pay cut, but it doesn't have to be a pay cut. So if you've been demoted, you can choose to treat that as a constructive dismissal. Now, with this gentleman that left us the message on our radio show, we don't know, or at least right now sitting here, I don't have all the information. I don't know yet if it's an actual demotion. But if it was, yeah, absolutely he'd be owed severance. And by the way, if you want to know if you're demoted, you can go to Pocket Employment Lawyer. And you can also go to Pocket Employment Lawyer to find out how much severance you're owed. So for this person, if he was in fact constructively dismissed, if he was demoted, he is owed severance. So let's just do what I said now. Let's go to pocketemploymentlawyer.ca. Let's plug his information into that pocketemploymentlawyer.ca website and see how much he's owed. So he's in a senior position, a director position. Let's say that he is 56 years of age. We know he's been there for 20 years. Company's not offering him severance because they say there's a job. But if it is a constructive dismissal, as you can see at the bottom of the screen there, he's owed anywhere from 18 to 24 months severance. 18 to 24 months. That's a lot of severance, even though he has not been let go. Same with you at home. If you've been demoted, if it's a true demotion, you may be able to treat that as a constructive dismissal and get severance, which again could be as much as 24 months pay.
You know, sometimes after the show, people have questions because it's just a 30-minute block of programming here, of course, and I'll give them another place to ask some questions when we're done if something piques their interest. Terminationquestions.com. Lior, as you know, is the website, and I want to get to one of these, read one of these out on the show today. Casey's the first one for the day, says, I've been extremely anxious about the pandemic and asked my employer to let me work from home. While the office appears to be decently safe, I don't want to take any chances. Does the company have to agree to let me work from home if I request this? I live with my husband and his boss is letting him work from home.
So this is probably, John, one of the top 3 questions that I've received over the past year or so. You know, I don't feel safe going to the office. I'd rather not. I'm able to do my job from home. So can my boss tell me that I have to go in? So here's the answer to that. Generally speaking, your employer is allowed to require you to come into the office, even if you can do your job from home. Now, that may be different in provinces where the government has implemented a mandate saying you have to allow people to work from home. If the government said you have to allow people to work from home, the company has to comply with that. If the government has not done that, then it is up to the employer. And even though I understand why many people would feel unsafe, who hasn't? I've felt unsafe as well. But in that situation, despite that feeling, your employer can require you to come back to work. So my advice is talk to your employer. Oftentimes you can reason with them, maybe work out some sort of a compromise. You work sometimes from home, sometimes from the office. Ultimately, though, if your employer says, no, you have to come into work, if you choose not to come in, that may be considered a resignation. Now, if you have a medical condition, that's different. If your doctor says you should not be in the office, you should only be working from home. If your doctor provides you a doctor's note to that effect, then your employer has to accommodate. But you generally, the employee, cannot on your own decide that you're going to be working from home. If you do that, that could absolutely be a resignation.
All right, we'll take our first short break for the day, Lior. Coming up when we come back, severance pay when a business closes due to COVID-19. We'll tackle that. In the meantime, 1-855-821-5900 and employmentlawyer.ca. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Employment Law Show, John Scholes and Lior Samfiru. We want to tackle this for the next few minutes, Lior, and that is severance pay when a business closes due to COVID-19. And I know this is probably a huge question that people have been dealing with over the last year, and you've had when you get phone calls and emails to the firm, and that is, does a business have to pay severance pay to employees if they've closed as a result of COVID-19? I'm thinking of the countless number of small retailers and mom and pop shops across the country as well, right?
Absolutely. You know, this is a very unfortunate situation. My gosh, I certainly have never seen this in all my years of practicing law or working as an adult. So I can tell you this, that the fact that a business shuts down, even if it's because of COVID-19, even if it's for a legitimate reason, that fact does not relieve them of the obligation to pay severance. In other words, a business that shuts down still has to pay full severance to the employees they are letting go. There's no way to avoid that. There's no way to say, well, because we're closed, we don't have to pay you severance. But then again, you remember the old saying, John, I'm sure, that you cannot get blood from a stone. So if the business truly has no money, they don't have any assets, they don't have accounts receivable, there's nothing coming in, it's possible that despite their obligation, they're simply not going to have the ability to meet their severance obligations. So I don't want, though, anyone to assume that that's the case. Just because the business shut down does not mean that the business cannot meet its severance obligations. There may be things that the business owns and money coming in from customers, former customers. There may be definitely things that can be used to satisfy those severance obligations to the employee. So a business closing does not mean you don't get severance, not at all. I've helped hundreds of people, even since COVID started, to get their severance from those businesses that's closed down, because that is the law. The law says they still have to do it. I don't decide that. It's not my choice. The law makes that very clear. Now, of course, John, bankruptcy is a different thing altogether. If a business is formally bankrupt in formal bankruptcy proceedings, the reality is employees will not get paid their severance. At best, maybe they'll get a couple of pennies on the dollar. But if it's not formal bankruptcy, if it's just shut down, yes, you still have to get paid your full severance.
So how is severance calculated as a result or during COVID-19? Or maybe the better question is, does the metric change at all because of COVID-19?
Well, arguably it does change. So we still look at the usual factors, which is your age, your position, and the length of your employment. In other words, longer you work, older you are, and the more senior a position, the more severance. But there's another factor that we're going to assess and look at during COVID-19, and that is the fact that there's just not as many businesses hiring. It may take you longer to find another job during COVID-19. Less businesses hiring, more people looking for work, people that have lost their jobs, so it's going to be harder to land. The fact that it's going to be harder during COVID-19 as it was before it is going to increase the severance. A bad economy, an economy that makes it more difficult to find another job, increases the severance. So not only do you get severance if you lose your job because of COVID-19, you may be owed even more severance than usual, all right? So you can never assume anything. Don't assume, oh, I work for a year, I don't get much. Don't assume that I get a week per year. That's wrong, that's false, it's not even close. None of those assumptions are true. PocketEmploymentLawyer.ca, your friend, your tool in assessing how much you're owed. Call me, but please don't make incorrect assumptions. COVID-19, if anything, means more severance.
Well, if I'm an employer in that case and I'm thinking, you know what, that's a lot of money if I have especially some long-standing, long-term employees, and I don't want to dip into the company coffers to pay them severance, is there another way? Can I give them working notice of termination?
Yeah, so oftentimes employers do this, and I've certainly seen this a lot over the last year, a lot more than I usually would see. Employers simply saying, well, instead of letting you go today and paying you severance, we're going to give you advance notice, a month, 6 months, 12 months of the termination of your employment. Now, if that's what the employer does, if the employer gives you in writing advance notice of your termination, that amount of notice counts towards your severance. So if you're owed 12 months severance, as an example, and your employer gives you 8 months notice, advance notice, then you're still owed another 4 months, but it's only 4 months because you've received 8 months severance. Sometimes people call that working severance because you have to actually work to get it. So an employer is allowed to do that, but chances are the employer is still going to have to pay an additional amount of severance at the end. And if you quit in the meantime, so your employer said to you, we're letting you go in 8 months, and you say, well, I don't want to wait for 8 months. I'm going to find another job and leave now. Sure, you can do that. There's nothing stopping you from doing that. But understand that in that situation, you would not get any severance. Even though it's the company that decided ultimately you're not going to work, because you chose to leave before your last day, that is still, in the eyes of the law, considered a resignation, means you don't get severance. So just because the company gave you advance notice does not mean they still don't owe you more severance at the end. They do, and likely will absolutely have to pay it. But if you leave before that last day, you give up your right to get anything else.
What we're talking about is severance pay due to COVID-19 when a business closes. Now, again, because of COVID-19, do I have to accept their offer on the spot? Has that changed at all?
No, and you may find even more pressure being exerted on you to accept severance on the spot or with very short period of time. You know, we're letting you go today and you have 48 hours to sign. No. That deadline continues to be meaningless. Your legal rights don't expire on some arbitrary deadline. In fact, your legal rights don't expire for 2 whole years. So that deadline is meaningless. And I've said this before on the show, on our radio shows for years and years, and I'll continue saying that. And COVID-19 has not changed it. A deadline in a severance offer is meaningless. It's a pressure tactic. That's all that it is. And if you sign it being under that pressure, and then you realize, wait a second, that was a mistake. I signed off and I'm owed another 12 months pay. You still cannot do anything about it because you signed. So no, COVID-19 or not, you cannot accept that offer until and unless you've gotten advice and until and unless you know that you're getting everything you're legally owed.
How about again, you know, this business owner, this employer wants to try to avoid severance. Maybe they own a different type of business under their leadership. Can they offer me a job at another business instead of paying me severance?
Well, in some situations that could certainly be possible. What you want to make sure there is that your service doesn't start from zero. So you don't want to be accepting a job and start service at zero. As long as we all agree that my service is going to be deemed continuous, then there's no real downside to do that. If the second company at some point lets you go, then you're going to be owed full severance because your service is continuous. What you don't want is give up your severance, start a job with zero seniority, lose that job 2 months later, and now you don't get anything. So no, not a good idea. But as long as your service is continuous, that's absolutely fine. It may be better to continue to be employed than to be unemployed. That's absolutely fine, but you want to make sure, you want this in writing, that your service is continuous. Your service does not start at zero. As long as you do that, you're protected.
Underneath all these scenarios that we just talked about the last few minutes, at what point do I reach out to you, or does an employer about to be an ex-employee reach out to you?
Well, anytime your job is impacted because of COVID-19, or doesn't have to be because of COVID-19, but we're talking specifically about COVID-19 now. If your job is impacted in some way, you have to give me a call. So laid off temporarily. If you're laid off temporarily because of COVID-19, reach out to me. Why? Because that layoff is not legal. An employer, for most non-union employees, does not have a right to lay off the employee temporarily. So that's one. If your job has changed because of COVID-19, your employer wants to change your hours, reduce your pay, change your shift, change your compensation structure. All those things are things that an employer is not allowed to do, even if it's because of COVID-19. That has not changed that analysis. If your job certainly has been terminated, you lost your job, maybe your employer is not bringing you back from a layoff, maybe they're just not scheduling you for shifts. Anytime your job is impacted, COVID-19 related or otherwise, you have to give me a call. And time is of the essence, because if your job has changed somehow, the terms of your employment have changed, if you don't do anything about it, you simply continue working, you're considered to have accepted it. And once you've accepted it, you can't go back. So time is of the essence.
Again, employmentlawyer.ca is the website you want to go to find one of our long-running radio shows near you. By the way, that particular portfolio is always growing, so we're going to be a radio station near you sooner or later, guaranteed. Lior, I want to get to number 2 phone call from our radio shows right now.
I was laid off in late from a federally regulated company as a temporary layoff, and they have not called me back. They laid me off due to shortage of work, which I have discovered was not necessarily a shortage of work, because they have hired people in my department since my layoff, and I'm wondering what my recourse could be in that regard.
Another one of the top 3 questions that I've been getting, over the past year. I've been put on a temporary layoff. They say it's shortage of work. I don't necessarily believe that. What are my rights? So here's the answer, John. It's not about the reason they put you on a layoff. Maybe the reason is honest, maybe it's dishonest, maybe it's accurate, maybe it's not. That's not the issue. The issue is that despite the reason, the layoff itself, the temporary layoff itself, is not legal. For most individuals that are not part of a union, an employer does not have a right to lay you off temporarily, regardless of the reason, even if they have a legitimately good reason. If they do that, if your employer puts you on a temporary layoff, now you, the employee, have a choice to make. Choice number 1, you wait. You wait and see what happens if they call you back to work. You could be waiting for months and months and months. Option 1, fine. Option number 2 is you can choose to treat that layoff as a termination of your employment. Again, we call that constructive dismissal. You can choose to treat that as a termination and get your severance. And for many people, I think that will be a preferable option than to wait months and months and not know what's happening, not get paid, try to live off government benefits which only pay you a fraction of your salary. You could be owed 2 years of your total compensation. If you've been laid off, whether you're federally regulated or provincially regulated, you can choose to treat that as a termination. Before you do anything, you want to reach out to me so we can discuss the details.
Okay, coming up here, when you're staring down the barrel of a new contract with a new payment schedule, what do? We will tackle that after a short break. We'll continue. Lots more Employment Law Show is on the way. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back. Thanks for sticking around. Employment Law Show. John Scholes, Lior Samfiru. The website employmentlawyer.ca is where you go to catch the radio show. And want to get this one in quickly with our remaining time. Lior, phone call number 3 from our radio program.
I've been a salaried employee for 6 years, and my pay is set up where it's salary plus commission. What they've done is they have changed the commission amount, reduced it, but increased the salary, which it ends up netting the same. I'm fine with, but my question really is about, say in 6 months from now, they decide to let me go. My severance would be as of my new contract, or do they take into account the prior 6 years that I've had, the new contract with the new salary and new commission structure?
It's a great question.
It's a great question. And let's be very clear. Your seniority doesn't start at 0 just because you sign a new employment agreement. By the way, you have to be very careful with signing new employment agreements, because even though they cannot extinguish your service, they could try to limit future severance. So you have to be very careful. But for her, she signed a new agreement with a new pay structure. She's fine with that pay structure. Her concern is, well, if they let me go, does that mean that my seniority started at 0 because I signed that contract? No, absolutely not. So let's take her information, John. Let's plug it into Pocket Employment Lawyer, just so she and everyone else at home can see how much severance she would be owed if she lost her job. So she's an account executive, been there for 6 years. Because her service doesn't start at 0, just because she signed a new contract, as you can see in the bottom there, she could be owed as much as 8 months severance. 8 months severance is what she's owed. No, her service does not start at 0 just because she signed a new contract.
Let's get to one quickly. TerminationQuestions.com is where you want to go. Lior Fern says, I was promised a promotion last year. This year, I didn't get it. The promotion was given to someone else, and I was let go. Would this be considered discrimination?
So, discrimination implies that the employer did something based on a prohibited ground. They did something to you because of your age, your disability, your religious beliefs, your ethnicity. If, for example, Fern did not get a promotion because the company says you're too old, or because they say we want people from a different ethnicity in this role, that is discrimination. That is illegal. You cannot be passed over for a promotion or for anything, really, based on a prohibited discriminatory ground. But the fact that he did not get the promotion in and of itself is not a discrimination. The reason why he didn't get it may be discriminatory. So for Fern, if in fact he didn't get it because of a discriminatory reason, then we need to talk about it. Otherwise, an employer can choose who they promote and who they let go, as long as they pay proper severance. So it's possible that for Fern, the real issue is severance. How much severance do they actually owe him? And remember the rule of thumb, John, 90% of time, 90% of people are offered significantly less severance than what they're actually owed.
Same as a pay raise. They don't have to give you a pay raise, and they can give it to the guy next to you if they want, right? It's not nice, but they can do it.
They can. Again, not nice. It's certainly going to make you unhappy, especially if you've been promised that you're going to get it. But at the end of the day, you can be passed over, again, as long as it's not discriminatory. And if the company ends up letting you go, not happy, it may not make the company a good person or a good company, but they can still do that legally as long as they pay you your full severance.
All right, good stuff. We're done. You still have more questions to reach out. Here's how you do that. 1-855-821-5900. Help at employmentlawyer.ca. Just employmentlawyer.ca. That's the website you go to where we pull the radio show phone calls. And then finally, the website you should use right off the top, pocketemploymentlawyer.ca. Free and anonymous. It's there for you 24/7. We'll catch you next time in the Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.